Everyone, we're on the record in the matter of Karen Kelly versus William Kelly. This is file number 21-18459DO. Counsel, please start with your appearances.
Travis Grote on behalf of the plaintiff, Karen Kelly, who is also present via Zoom, Your Honor.
Good afternoon, Your Honor. David Delaney appearing on behalf of William Troy Kelly. I was expecting him, but perhaps he's still connecting.
I don't see him in the waiting room. If I see him, I'll certainly kind of keep an eye on him and I'll bring him in as soon as I see him enter my waiting room. He's not in the waiting room yet, though. So, counsel, we're going to get started here. We have a motion for entry of domestic relations orders and for enforcement of the judgment and request for sanctions. I've had a chance to review the motion. I've had a chance to review the background of the mediation agreement, or not mediation agreement, the confidential settlement agreement, as well as the judgment of divorce terms. I've also seen the defendant's response. I really don't think I'm going to benefit from oral argument. On the other hand, there are some things that are not clear to me, and so I'm going to allow some brief oral argument from the attorneys if you think you can help me. Mr. Grote, this is your motion. Outside of your written request to basically have the court order these QDROs or other disbursements to be done, what else would you want the court to be aware of?
Well, Your Honor, I'm happy to report that the one issue, which would be the last issue that I addressed in paragraph 8 of my motion with regard to the WBA accounts, that has been resolved since I filed the motion. That account has been divided. And I just want to be clear, Your Honor, that DC Voss and Company is David Voss. That is the financial advisor for both parties. After receiving the defendant's response, I just wanted to point that out to you, Your Honor. So at this point, the only two issues are the entry of the two QDROs, which I attached to my motion as Exhibit C, Your Honor. Specifically, there is the HR 10 QDRO and then the Walgreens QDRO. The corrections that Mr. Delaney is referencing in his response of pleading, those corrections were already made quite some time ago. As I pointed out in the motion, Your Honor, numerous communications were sent. I received one communication back from Mr. Delaney saying he would reach out to his client. I know that Mr. Voss attempted on numerous occasions to get in touch with not Mr. Delaney himself, but with Mr. Kelly, William Troy Kelly, and he was not able to get any responses from him in terms of getting these QDROs entered. So the two QDROs that I attached, Your Honor, Exhibit C, those are the two QDROs that have been prepared, have been modified appropriately. The one reference to the December 8th communication from DC Voss on page 3 of defendant counsel's reply, that was actually my email to him on December 8th, 2023, which he never responded to. And my December 8th, 2023 email included the email that he attached to his response, which if you look at it, Your Honor, that email drafted by Dave Voss is dated November 6th. That was sent to both the parties. My understanding was that Mr. Kelly didn't respond to that. My client notified me of that on December 7th. I then sent communication to opposing counsel on December 8th. That's his reference, December 8th, the email. That was my email to him, sending him the documentation saying, if I don't hear back from you, we're going to have to file a motion to get these entered. My client continued to attempt to work with Dave Voss to try to push the defendant husband into getting these resolved. She was not able to do so. I had not received any response from opposing counsel to those communications I sent him, including the December 8th email that he references in his response to pleading. The one email I received back from him was on October 24th of 2023 saying he would touch base with his client. Once my client notified me that she was not able to get anywhere with the financial advisor, who again is the financial advisor for both parties, he's been working diligently trying to get these matters resolved. I then filed the motion, and again, our relief requesting that we're requesting, Your Honor, would be that the two QDROs that are attached as Exhibit C to my motion, the court order that the parties sign within 7 days of today's date, and I can effectuate the signatures of the same, and then we're requesting attorney fees pursuant to the affidavit that I attach, Your Honor, in the amount of $1,675.
Thank you, Mr. Grote. Mr. Delaney, your response outside of your written response, I think.
Well, specifically, let's start with the first asset that counsel referenced in this case, and that's the WBA retirement. My client advised that it was resolved in this case, and I don't have a cavalier approach when I'm dealing with $1.5 million across the board. I would need a release from Mr. Grote's client, number one, and or an amendment to the property settlement agreement, because that agreement provided for a QDRO for that asset, but it wasn't required, and we had to pay $500 to a company that never prepared a QDRO because it didn't apply. But I simply can't accept verbal representations and expose my client to liability. I need a release from his client that asset's resolved. My client will sign that. And if that was the case, I could have been notified of that before this hearing and reviewed that. So it has to be in writing. The court deals with divorce cases. You don't make cash child support payments and then expect enforcement. Now, as to the other two assets, we had a settlement agreement that provided Gomatis would prepare the QDROs. Then I get injected a company called DC Voss. I don't know who they are. My clients may know them, but he indicates in his email that he drafted the QDROs. Well, has Gomatis approved that? And has Ernst & Young and Walgreens, those are the two other QDRO companies, have they approved that? I can't advise my client to sign a QDRO that, it looks like my client's coming on now, my client to sign a QDRO drafted by a company that I don't know who they are. And whether it's approved by the company and divides the asset properly. So when we're dealing, that exposes my client to liability and me to liability. If I get a communication from counsel indicating that another party's prepared this QDRO, and additionally, Judge, the QDRO was never signed by Mr. Grote or his client and still hasn't been signed. But he's here in court saying that we didn't sign it, so we have liability, we have to pay attorney's fees. I don't want to be on the receiving end of mismanaged $1.5 million in funds with my client, with a QDRO prepared by a party I don't know who they are, and then today being told something is resolved and that's all taken care of. I need to see releases, and as I propose in my response, Judge, I would propose that Gomatis tell me that those QDROs are acceptable, that they drafted them. In fact, that Ernst & Young and Walgreens approved those too. And it's been a year and there's been no communication. That's a long time for a $1.5 million to sit out there for both of the Kellys in this case and counsel. So certainly inappropriate to demand costs in this case, and definitely inappropriate to saddle on me an obligation just to tell my client to start signing documents and settling accounts without a written release. And that avoids liability for the court going forward. Thank you.
Mr. Grote, who prepared the Exhibit C qualified domestic relations orders?
Mr. Gomatis prepared the Walgreens, the HR 10 Ernst QDRO, and the second one, Your Honor, that's attached. I believe that Mr. Gomatis also prepared that. I'm basing that on the communication in part that was sent to Mr. Delaney on December 8th, which included a letter to Mr. Gomatis from the Ernst & Young group with requesting a modification to that document. That modification was in fact made by Mr. Gomatis, and you can see that, Your Honor, that the modification is made on page 3 of that document, where that the letter requests that it include the participant's personal account, and Mr. Gomatis made that modification. Just so you're aware, Your Honor, the property settlement agreement on page 11 specifically states if it is necessary for separate domestic relations orders.
I read it, Mr. Grote, and I don't need additional oral argument on the point. I just wanted an offer of proof, at least for the record, who prepared them. I know what the agreement says, what both the property settlement agreement and the divorce judgment say in terms of costs. On that point, as to the brother counsel's offer of proof, did you have anything to contest that, Mr. Delaney?
The email from DC Voss says I prepared the QDRO. So he's pretty clear about that. And that communication came from Mr. Grote. So let me jump to that real quick. The Walgreens, he says, yes. He indicates that I prepared the quadro, second sentence, middle paragraph. And then in the first paragraph, he says, I've attached a copy of a revised quadro. So does that mean that DC Boss revised that quadro? Clearly, they drafted the second quadro. And then we don't have a quadro that we can apply for the, apparently for the settled account. So it's very unclear and remains unclear to me who prepared these quadros and if they would be approved for division, whether Goldmatis has even seen these.
So there's too many questions, counsel, and not enough answers. And the court's duty when questions are phrased is to settle them with answers. And so that's what I'm going to do here today. This case has been wallowing for 2 years. The settlement agreement was issued in February of 2023. It is January of 2025. $1.5 million is a lot of money, but a quadro is not a particularly difficult document. If Mr. Kelly had questions about the document or its effects, or the quadros or their effects, or if his attorney did, then his attorney's duty is to question those things before the court hearing and to do those in a way that is sensible to me. Your response, Mr. Delaney, doesn't make sense to me because you indicate to me as a remedy that the quadros appear to require amendments, yet you tell me nothing about what amendments are needed, and that's not enough. And so quite clearly in the motion, the request was laid out entirely to me, clearly by Mr. Grote. He wants me to order that those quadros are signed. The response does nothing to identify any concrete problems with the quadros, but instead only asks rhetorical questions about what could be in it or what the effect could be. So while you might be right, Mr. Delaney, that there's duties that you have, those duties don't require you to simply do nothing except question things. They require you to investigate them and work with counsel if you want to. But quite clearly, and just as clearly, Mr. Grote is in the position representing Ms. Kelly, who 2 years ago had a written agreement saying she was going to get funds. I don't make any finding about malice or bad faith, but I make a clear finding that what was intended to be done and what was contracted to be done in the property settlement agreement hasn't been done. And the only thing that I can glean or imply from that is, Mr. Kelly, I don't find that you're making any type of bad faith failure to do things, but there is a clear, on the other hand, failure to do things. You are the one who has these assets in your possession. You are the one who has to have the assets transferred through a quadro. It is Mr. Grote, on behalf of Ms. Kelly, who has been asking through your attorney to try and get these things. And based upon the representations of Mr. Grote, which I find credible, has also been trying to suggest and work with this boss company to try and get these things issued as well. If you don't understand the terms, then you question them and you get answers. But you can't simply sit along and do nothing in 2 years. That requires Ms. Kelly to file a motion to have the quadros entered. And that's exactly what happened. And so this isn't the court issuing sanctions. This is the court following the attorney's agreement and the parties' agreement. Because it was the parties' agreement that said, if it's necessary to file motions to get these things issued, meaning if I have to hear them, then the party who was successful is going to be awarded costs and attorney's fees. Again, that's not me imputing sanctions. That's not me making a finding of bad faith in any way. That's me upholding the plain contract language between Ms. Kelly and Mr. Kelly, signed to and agreed upon by each of the attorneys. So it's not an unfair request in any way. So I'm going to not only grant the relief that's requested I'm going to order that within 7 days from today's date. Each of those qualified domestic relations orders, one for the HR 10 account and the other for the Walgreens account, are to be signed by all four parties present. Well, 2 attorneys, 2 parties. I'm also going to order that sanctions are awarded. And again, I'm using the word sanctions. That's what was requested. But I don't find it's because of bad faith. I find it's because of the language that the parties chose in their settlement agreement. I'm enforcing it. Ms. Kelly had to have this motion filed. She should not have to bear the burden of that cost because it's her benefit that has been lost for these last 2 years. And so I do find that to be appropriate. If you want, Mr. Delaney, I will give you an opportunity to challenge and issue a counter offer of proof. From what I've seen, it appears entirely reasonable for the amounts that have been suggested. The hourly rate is within the percentile of general fees here in the community based on the economics of law survey, as far as I can tell. But I'll give you an opportunity to go through that in more detail if you want to, Mr. Delaney, and challenge it. But I make the preliminary finding that the sanctions are appropriate because the parties negotiated for that exact term. If you have a specific challenge to any of those listed amounts, the time or the dollar amount, then you're entitled to a hearing, but you must file that objection within 7 days of today's date. So Mr. Grote, I need you as a prevailing party to prepare that order. Number one, the signing of each of the QDROs within 7 days of today's date. Number two, that if Mr. Delaney on behalf of this client has any objection to the affidavit and bill of costs, you must file an objection within the next 7 days of today's date, and then the court will set it for a hearing. If it's set for a hearing, then Mr. Grote be prepared to provide testimony regarding your reasonable hourly rate, what you actually charged, and anything else to support your claim for costs. Do you have any questions regarding the court's order, Mr. Grote?
I do not. Thank you, Your Honor.
Do you, Mr. Delaney?
Judge, if I could save the court the time of objection and just state that he's got 3 hours to travel to court and back, but we're by Zoom. So if he takes that off, we're probably good.
Well, we've been here 15 minutes, Mr. Grote, and I recognize that times are a little different. Ordinarily, you'd have to travel, you'd have to wait for a cattle call. I came on the record right on time. We've been 16 minutes on the record. Did you wish to amend that portion?
Yes, Your Honor, of course. I would amend that to reduce the 3 hours down to 0.25, Your Honor, a quarter hour.
Okay. And then if that's the case, you approve of it. I'm not saying you approve of it, Mr. Delaney, but you have no other objection to it.
That's correct. I think I'll talk to my client, but I think if that's based on the court's order, if the 3 hours, well, the 0.25 and the 3 hours subtracted, we'll probably not need to involve the court for further proceedings on that issue.
And that's fine. So talk with your client. You have 7 days to file an additional objection. If there's no additional objection filed, Mr. Grote, then just make sure your order that comes in later indicates the exact amount